Senators, once you've logged in, you may now proceed to vote. Senator Tabitha Keroche, may you move to dispatch and get some assistance. We're now going to allegation number 2. It's been beamed on the screen. You may now vote.
Senate, even as the senators continue voting on the second ground touching on gross violation of Articles 147(1) and 152(1) of the Constitution, all this touching on Deputy President Rigathi Gachagua. Remember, after the voting on all the 11 counts where the senators are voting electronically, it will be communicated as to how that voting pattern will have played out. Remember, only 2/3 are needed to officially impeach Rigathi Gachagua as the Deputy President of the Republic of Kenya. 2/3 translating to roughly 45 votes. So remember, Rigathi Gachagua will stand impeached if he is, if the senators actually vote to impeach him on any of the 11 grounds. So as you can see right now, those are the percentages on our screens. Those voting in the affirmative have been seen. Those voting against the impeachment motion are actually displayed as well. That's the second ground. They'll be going till the 11th charge. So we just want to hear from the Speaker, who seems to be ushering the senators to the next count, which they'll be voting on, the next charge rather, which they'll be voting on. Remember, a total of 11 charges so far, right, Ashley?
Oh, definitely. But it's equally good to just remind our viewers that Article 150 of the Constitution governs that the Deputy President's impeachment can be based on 3 grounds. That is gross violation of the Constitution or any law, committing a crime under national or international law, and equally gross misconduct. It's equally important to note that yesterday, Deputy President Rigathi Gachagua pleaded not guilty to the 11 charges leveled against him. But even as we talk about yesterday, Jesse, it's been an interesting afternoon.
Quite
the
so.
Events that transpired today, at the Senate.
Yes, and we'll definitely be evaluating what played out. Let's
3,
just listen in to what the Speaker is saying.
Can you beam it? There we are. Honorable Senators, you may now proceed to vote on allegation number 3.
All right, live pictures from the Senate, even as the senators continue voting on all the 11 charges facing the Deputy President of the Republic of Kenya, Rigathi Gachagua. And we're joined in studio by Javas Bigambo. We'll just be crossing over to...
Let it be beamed on the screen.
He has to
Honorable
say.
Senators, you may now proceed to vote.
Okay, it seems they're voting on the other grounds. Let's just converse on what exactly is happening, Javas. It's great to have you with us on an instrumental day in Kenya's history. We seem to be voting on the grounds. I'm not sure which specific ground this is, but according to the first charge where the senators voted, up to 50 voted in the affirmative. What exactly does that mean? Does the Deputy President of the Republic of Kenya already stand impeached?
Well, Jesse, thank you for having me tonight. What is very critical and clear to be understood by citizens in this country is that of the 11 charges that the Deputy President is facing, if any of the charges is affirmed by the Senate, on that single charge, the deputy president will have been considered to have violated the Constitution of Kenya 2010 and the laws of the land, and that alone makes the deputy president to stand impeached by the Senate. So, as a matter of fact, we all fathom this fact that all the 11 grounds do not have to be affirmed by the Senate for Rigathi Gachagua to be impeached as deputy president of the Republic of Kenya.
Interesting.
So just to get it right, for example, if you go back to Article 151B of the Constitution, it lists 3 grounds. So if he's guilty of gross violation of the Constitution or any law, then he goes, regardless.
Remember, Ashley, that when Rigathi Gachagua on the 13th, I think I do recall, September 2022, he took his oath of office. He said he will defend and protect the Constitution of Kenya, and he sought the help of God. Defend and protect. If he violates the Constitution that he affirmed to defend and protect, then he will be impeached on the basis not just of the oath that he took, but on the basis of Article 150 of the Constitution.
Okay. But I want us to now just go back to what we saw happen at the Senate earlier today. And we saw the lawyers and the legal team of the deputy president argue that he has a right to a fair hearing and a trial, which others might argue did not happen because the deputy president did not appear at the Senate when he was supposed to go to the floor of the House as a witness.
Actually, after 2 days of severing, the full majesty of legal and political drama in the Senate, we are seeing that tonight, the year of our Lord, the curtains are set to fall. And as we look at all this, in the closing hours of this entire process, the lead counsel of Rigathi Gachagua, senior counsel Paul Muite, argued that in the interest of justice, it is important that Senate gets to adjourn and give room for the deputy president to recuperate and recover if possible, to enable him appear before the Senate for purposes of being cross-examined. Remember, as we look at all this, the deputy president filed written submissions, including affidavits. All these are substantive and consequential. Now, when you look at Article 47 of the Constitution, and even matters that you are citing, the issue of fair trial. Fair trial is not just a theoretical issue in the Constitution. It is something that is properly sheltered and preserved by the Constitution. So, as a matter of natural justice, Rigathi Gachagua has to be heard, has to be represented, does not have to be condemned unheard. But what is the operational definition of the term heard in law? Heard does not mean just being in terms of sound bites and speaking out. By way of even his written submissions and affidavits, that is one way of submissions, and he will be heard, that will be considered. The other thing is appearing in person and voicing affirmations to the affidavits and the written submissions that he made. The cross-examination could be a question of corroboration and him owning up the statements that he initially wrote. And so far I can argue that it is going to be a very interesting unfolding situation in the weeks ahead, how the counsel for Rigathi Gachagua, who stormed out of the Senate in protest, will perpetuate this issue of the right to be heard before the courts in the interest of Rigathi Gachagua, now that Senate is carrying forward or carrying on with the issue of impeachment of Rigathi Gachagua, pursuant to the timelines and the mandate that falls upon the shoulders of the Senate by way of the Constitution and the standing orders.
Because that's what exactly the lawyers argued on, you know, sub-article 6 of Article 145, and it states that the Senate shall, after according the president, that in this case the deputy president, an opportunity to be heard, vote on the impeachment charges.
Exactly, and that's why I said the issue of according or affording the right to be heard. So far, in the last 2 days, Senate has been hearing or listening to the charges by way of the National Assembly presenting the charges. We have had counsel for Rigathi Gachagua presenting themselves. Remember from the opening statements, up to the time when it was announced that Rigathi Gachagua is now indisposed. So Senate has been listening to both sides. I can assure you that except for the 2 hours or 2.5 hours that were remaining to conclude the entire work of listening to the charges and the evidence and corroborating for purposes of substantiating any of the charges, Senate has done its best. And remember that even after the lunch break, Senate adjourned to make sure that counsel for Rigathi Gachagua avails their client for purposes of the cross-examination. In terms of matters procedure, Senate has done what it's possible under the timelines that it has to consider what is procedurally fair and just for Rigathi Gachagua. Of course, remember that the high walls of separation of powers grant the legislature, in this case the Senate, to consider its work within the framework of operation, which are the standing orders and the constitution of the land.
Okay. Well, what do you think will play out in the corridors of justice? Because taking a look at what the Deputy President's team did earlier on, up to 26 court cases were filed in the corridors of justice, and them walking out right after the senators decided not to extend this sitting to Saturday to give the Deputy President time to recuperate. What will the courts say? There's some who argue that an impeachment in absentia is a flawed impeachment.
The worth of jurisprudence affirms that actually the corridors of justice are not static. They are elastic. Okay. And that's why the pronouncements of the courts and various judgments always expand the brackets of justice in the interest of justice for man or mankind. I do anticipate that in the days and weeks ahead, we are going to see an unfolding melodramatic scenes within the corridors of justice in Kenya, where counsel for Rigathi Gachagua will vociferously argue in the interest of Rigathi Gachagua that he was condemned unheard, and that actually Senate did not consider the fact that he's now suffering malady and his indisposition did not afford him an opportunity to be heard in person before the Senate. But question would be, and of course you've heard Senior Counsel James Orengo argue, that actually beyond the issue of the timelines, Rigathi Gachagua has made written submissions, has sworn affidavits, and even various witnesses. And remember that actually it is the National Assembly that stands prejudiced by failure to cross-examine Rigathi Gachagua, the Deputy President. Looking at all these, it affords Kenya the opportunity to expand jurisprudence on the issue that so far has remained untested, on the issue of impeachment of a president or deputy president in the circumstances. So I think in the coming couple of weeks and days, we are going to see the courts trying to exercise their various jurisdictions in terms of discharging the authority, listening to the various grievances, and it will be exciting to see how Kenya, being a young and progressive democracy, is going to be forging forward on the frontiers of democracy and constitutional law on how the impeachment of a president or deputy president is going to be safeguarded within the annals of history, and how Article 150, for example, on the impeachment of a deputy president, even in future, is going to be looked at through the lenses of affording fair hearing, and how the legislature can conduct procedurally the issue of impeachment of a deputy president.
Speaking of fair hearing, rather, it takes me back to what the Deputy President had to say about Justice Esther Maina, because he was quite critical of the fact that the judge apparently did not give him a chance to defend himself. So it's a little bit similar to what you anticipate might play out in the corridors of justice. Speaking about Judge Esther Maina, let's talk about that. Is it a personal vendetta against the judge for a ruling that wasn't made in the DP's favor? That was a case argued by the National Assembly's legal counsel. The DP side claimed he filed a complaint with the JSC, but equally he did launch a scathing attack in public. So does the Deputy President have the right to publicly criticize a judicial officer?
By seeming to exercise that right of the freedom of speech and expression, there is so much left that leaves a very bad taste in the mouth. That Deputy President Rigathi Gachagua belongs to one critical arm of government and very high ranking.
Yes.
as a deputy president, to venture into the space of the judiciary and attack the character and the person of a judge, it leaves a very bad taste in the mouth. And in fact, it's quite condescending. It demonstrates that Deputy President Rigathi Gachagua had little respect, not just for the judiciary, but even for a ranking member of the judiciary who is a judge. It leaves a very bad taste in the mouth. And in fact, when you appreciate the very import of separation of powers as a doctrine, it is important that each arm respects the other arm, because the walls of separation of powers are very high, a perimeter wall that must be respected. It is a very impregnable wall.
Okay.
And I think moving forward, it lends us a lesson, even for the political class, that even if you disagree with a member of the judiciary for a particular decision rendered while in the execution of their duty, it is important to respect them and respect the judiciary as well.
Okay, I understand the speaker is about to make an announcement, but as we wait for it, you know, we're on uncharted territory of the Constitution. From where you see it and looking at this process from the National Assembly to where we are, what precedents does it set?
You see, Ashley, I recall the words of Justice William Douglas in the decision of Griswold versus Connecticut, when he said, and I quote, that the Bill of Rights within itself has got certain critical penumbras, from which penumbras there are certain guarantees of rights that emanate from those guarantees within the Bill of Rights as a canopy. When you look at the entire process of the impeachment of the deputy president, it lends us one lesson, that actually we have not tested the elastic limits of Kenya's constitution. And this is one opportunity for testing the elastic limits of the constitution. To what extent can they stretch? Remember that just this afternoon, when counsel for Rigathi Gachagua came to pronounce that he is taken ill, everybody was left baffled. What follows next? Because Kenya's history has never suffered such kind of a critical situation in such a nick of time of an impeachment that is historical. And judiciously, the speaker granted latitude for counsel to seek the status of Rigathi Gachagua deputy president and made another ruling. In fact, one thing that is very judicious of Speaker Kingi is that he even brought it to the floor of the House and made a supplementary motion to consider postponing the sitting of the Senate to a special sitting on Saturday. The Senate, in its right, decided to continue the business of the day. So that's one thing that we learn, that actually every moment is an opportunity for us to learn. Secondly, is that we as a people, led by the Constitution and the laws of the land, it is important for us to respect the Constitution of Kenya 2010 that we gave unto ourselves by way of the 67% of the people in 2010 who voted in affirmation of it through the referendum. Thirdly, I think the other thing is that this being a classroom without walls, this entire political legal process, that it is important for us to clean house, make politics clean, and the Constitution could be the safest detergent if at all institutions work the way National Assembly and the Senate have worked expeditiously to ensure that we get to run away from the kind of politics that are retrogressive, kind of poisoned chalice. Because, Ashley, let me ask you, in the circumstances that Rigathi Gachagua, for example, is not impeached, or, for example, the courts get to grant him appropriate reliefs that do not have him vacate office, how will Rigathi Gachagua work with the cabinet? How will he work with the president? How will he work with the Council of Governors, at which he is at odds? I think for purposes of interpreting the Constitution of Kenya 2010 through Article 259, constraining the Constitution in a manner that fosters good governance and the rule of law, it is important that we get to have politics that works, not just for the ruling party and the ruling coalition, but works for the country. And
it's a good thing you mentioned the issue of interpreting, because everyone does it differently. And there were questions that were being raised in this afternoon when we saw what happened with the deputy president falling sick. And many were saying, does the plenary have a time limit in an impeachment process? Because you see, the Constitution says the committee. So where does that leave?
Ashley, good thing is that law and its interpretation cannot be homogenized. And that's why there are various schools of thought. people belong to various schools of thought. Good thing about schools of thought is that they don't ask for school fees. And so, because of people belonging in various schools of thought, that is one of them. And because it cannot be homogeneous, even though as lawyers we went to various schools of law, interpretation is not even the work of counsel. It's the work of the judiciary. But we help society to understand the law. I will tell you this, Ashley, that I think it is important for us to see that the interpretation of the law should be in such a way that progresses the society in a way that makes it not just cohesive, but progressive and better, not otherwise, or not inverted.
Okay, I want to touch on one of the charges the Deputy President is facing, touching on the National Intelligence Service, because he's criticized for sort of letting the cat out of the bag in terms of confidential conversations, yet he's a member of the National Security Council. So, from your take, did NIS truly drop the ball when it comes to the Finance Bill 2024 protests, or did the DP's speech in Mombasa stir the pot since he's a member of the NSC despite the spirit of institutional leadership? Can he raise these questions in the NSC forum? And is NIS immune to criticism?
Well, Deputy President Rigathi Gachagua, you say correctly that he let the cat out of the bag. I'm not so sure whether this cat had kittens. But let me put it this way, that it was improper for the DP to address critical issues of national security through the media. As a member, a ranking member for that matter, of the National Security Council, appreciating Article 238 of the Constitution, there are other procedural mechanisms that you could raise issues, even with the President, or even the Security Council itself. Secondly, we know that, as Robert Greene puts it in the 48 Laws of Power, that when you violate the rules of power and politics, then the unfortunate winds become the winds in your sails. Right now, we are seeing him actually struggling to manage those winds that actually are promising not just a hurricane, but a typhoon against his political survival. The NIS is not immune to criticism.
Okay.
But what nature of criticism is it? When an ordinary citizen voices against intelligence or security organs, it is acceptable. But when, for example, how would you take it if the president was to criticize the intelligence unit? The deputy president is the principal assistant to the president, not just a heartbeat away from the presidency. In fact, the deputy president is a semi-permeable membrane away from the presidency. To start criticizing the intelligence unit, he can actually potentially even criticize the military. How will he, if at all anything happens to the office of the president and it involves vacant, how will he work with the intelligence? How will he work with the military? Okay. That is what leaves the bad taste in the mouth. And one would want to argue that because of that statement by the deputy president, one may have wanted to conclude that at that moment politically he was dead from the neck upwards.
Interesting. So in your view, it is an impeachable offense. I'd like to evaluate your take on the deputy president's defense, because he mentioned he learned from the best. And there were video excerpts of the then Deputy President, William Ruto, actually criticizing the Inspector General of Police, slandering equally the DCI as well, former Kinoti. Well, what do you make of that, even as we appreciate that the Senate is voting on the 11th count currently?
Unless I have missed some context and issues, to the best of my knowledge, Jesse, the president is not on the cross.
True.
And is not facing impeachment motion. For the deputy president to bring in the issue that he learned from the best, and that the best to him is the rest that needs to be considered, I think he missed the boat by the river. Instead of defending himself and trying to exonerate himself, he tried to rope in the president and other people, sort of the analogy of a drowning man trying to clutch at the straw. I think the deputy president was trying to say that as you are trying to crucify me, why can't you crucify the president, because he too has walked this path? And that's why he started falling into the ditch. I think Deputy President Rigathi Gachagua loves holes too much that he has been digging too many of deep holes in the recent weeks.
But ain't it a quasi-judicial process? What happens to the, evidence? Because we saw senators argue that there's not enough evidence as much as it is a political process.
Oh yes, and they are right and wise. Because this is not about the evidentiary weight and value of the evidence adduced before the Senate. Because it's not a criminal proceeding. We are not having substantive judges of the High Court or Court of Appeal or Supreme Court sitting in the Senate. It's quasi-judicial because there are no substantive judges in the Senate. It is a political process that is predicated on fundamentals of law. And that's why the law provides that for an impeachable offense, it has to be based in law. It's in the Constitution.
Okay.
But the entire process is political. When you look at election petition E11 of 2022, the impeachment of Sonko.
Yeah, I'll have to cut you short. Apologies, Jarvis. We have to cross over back to the Senate. Let's listen in to what Senate Speaker Kingi has to say.